We are here today with Shri Pravin Faldessai. Thank you so much, sir, for joining us today. Beginning with the question, sir, I would first want to know your insights about this exhibition and the views of Maharajji.
I visited the exhibition in the afternoon. As I was anchoring, that concept which is displayed and an attempt is made to impress upon the public visitors that the constitution of India and the morals and values of Indian culture are so much deep-rooted that that's the only way we can look forward. That's the only future which the world has to look at. The manner in which it is displayed, it's wonderful, it's amazing. The starting with, I earlier also said it, that the term Bharat has to be used in place of India, which the constitution itself says that India, that is Bharat. But then it has to be inculcated, it has to be told to people. And that is the attempt which is evident here, that attempt is seen here. And this has to go longer.
In that context, sir, I would want to know how far do you think that it is feasible to incorporate all of these principles and all of these deliberations in our modern governance and legal systems?
How far it is possible to incorporate is the question which you will keep aside. How best we can do it is the question we should say, because whether it is possible or not, he must make it possible, because this is the required, and this is what we are living with, this is what we have been brought up with, and not only we, our generation, not our previous generation, but thousands of years of culture of this nation says that this is the manner in which the society is brought up to. I mean, the manner in which the values of family life, the manner in which the values of supporting each other, guiding each other and protecting each other are incorporated in this exhibition. This, I can't see any way that this is not possible to inculcate in the society. This has to be. By all means, it has to be done. So there is no question whether it is possible or not. We have to make it possible. We lawyers, the students of law, we advocates, the judicial members, and the society at large. We have to strive for it. We have to, put our best efforts to get this done.
In that context, sir, I would want to draw your attention to the larger theme of reviving our ancient principles. Like we already had a system of administration in place. We had Arthashastra, we had Niti Shastra. So how do you see of reviving those in modern governance, and how do you think that all of these concepts can be truly inculcated in constitutional values?
It can be done. I've been saying this, but today when I see all this exhibition I went through, I found myself right in saying that this constitution is deep-rooted in our own society. Thousands of years of our culture is truly reflected in the constitution itself. It's another case that how we live this constitution, how we apply this constitution in today's circumstances.
Right.
But if we try to correlate this constitution with the ancient concepts of our society, I think it is relevant then also. And it has to be relevant in future also, because although sometimes we were told and we were tried to be impressed upon that what was our culture was outdated, it is not required for this society. But the times are now proving that what we had earlier, like Vedas, like Ayurveda, like everything,
Absolutely.
is supposed to be the best. Like, for example, we have one judgment in our Goa courts, which is known as Tiger Reserve case, where there was a lot of discussion. We feel that this environmental law is come from these conventions of 1982 and 72, the Hague Convention, etc. But that judgment starts with a Sanskrit shlok, which is 52nd verse of some Mahabharata something,
Right.
which is there in Mahabharata already. What it says is that if you protect the tiger will protect the forest. If you protect the forest, tiger is the.
Okay.
So environmental law this is.
Right.
This is from
Absolutely.
Mahabharata, this is from Ramayana, and it is always there in all. We don't need any Hague Convention or Geneva Convention to tell us that there is something called environmental law. We lived environmental law. We have propaganda of environmental law, and it is there in our blood. Absolutely. Therefore, everything that was ancient, that was old, is relevant for today and it is going to be relevant for future.
So coming on to my next question, sir, it is related to Article 31B and 31C specifically. So in the discussion, a lot of contemplation was done that how judicial precedents kept on building up on it. For example, there was I.C. Golaknath, there was Shankari Prasad, there was recognition from the judiciary that this is not right, but nobody took the initiative to maybe strike it down. So that was a statement that precisely you said. So in that context, I would want to know that it is something which, is it some gap that the judiciary has to bridge, or is it some mechanism, or it is some legislative initiative that needs to be taken with respect to catering to such rights and balance between fundamental rights and state's responsibility to protect it?
As far as Article 31 is concerned, that got introduced after the Bihar Reforms Act initially it was struck down, and then the Parliament wanted to protect it, so it amended the provision and brought in this Article 31B. And that is that point of time. As I said earlier, also there was a letter from
Right, sir.
the AG of Madras in that context. And Article 31B came into picture. Bihar Land Reforms Act is the first act that is incorporated in Schedule 9. Everything was challenged in Shankari Prasad's case. A lot of discussion, a lot of deliberation on that. They fell short of saying that it is unconstitutional and striking it down. But discussion is there. If we see the discussion in the judgment, there is a flavor that the court felt that this is not correct thing that has happened. But then it was not struck down. Okay. 10 years later, many acts were taking shelter of Schedule 9, and it was getting populated. So again, there was a challenge. What was in 1961 there was a case where again there was a discussion, and which again went on the same. It was a split verdict, and again it was in the same manner discussed. There is a flavor that the court felt that this is not correct, but then they said that it cannot be done. That is where the theory of basic structure was slightly introduced by Justice Nigolkar then. But there also Article 32B remained. Then Golaknath comes. Then in His Holiness Keswanand Bharti's case, there is a lot of discussion about basic structure and all. Then Minerva Mill comes. Then B.N. Rao's, then many other judgments. Indira Gandhi's case. Everywhere there is a discussion, but 31B remained on the statute. But it is now stand diluted. The court says that it should not be populated with more acts without being tested on the touchstone of His Holiness Keswanand Bharti's case, etc. But in that sense, there is some protection. But yes, this article remained in the book.
So we also discussed about aspects like if there is something not falling within the ambit of Part 3, if it is not falling within the fundamental rights. So as such, it can be struck down on the basis of doctrine of proportionality or arbitrariness, all those. So don't you think that can be invoked possibly to eliminate such provisions which essentially hampers...
Certainly, it can be, but we have no answers as to why the court, considering those cases at that point of time, did not do. It can be done. As long as after 1973, as long as it does not affect the Constitution's basic theory doctrine, everything can be considered in that manner. We have no answer why it was not done.
Absolutely, sir. With that, we come to our last question, which is essentially that does the reading spirit of the Constitution risk subjectivity, or it is essential to preserve constitutional identity?
Both, we would say. The constitutional identity has to be preserved, as I said earlier. And as this entire event which is there, it also gives the flavor that the identity of the Constitution must remain. Identity of Bharat and identity of Bharatiya culture must remain. And that will remain in the Constitution. So yes, it has to remain in that manner.
How do you think that the youth can take up all of this? Because we have been essentially told a lot of time that we have to practice the Western system, or we have been, I think there's a lot of thought process of youth that we are much affected by the West system of doings, be it very basic in the sense of wearing things, speaking, anything else. So how do you think that the youth can be motivated to, believe in their own roots, believe in their own culture, and take up that as their primary fundamental, and then maybe look towards the best for anything else.
Now we are talking about today's youth, but those have taken the Western culture as Western. It's not a culture actually, but the Western style of living was not taken by today's youth, but it was taken by a youth then, maybe 50 years back.
Right.
They started, deviating from Bharatiya culture, and they started going towards the Western style of life. And now it is proving to be failure. Western societies have failed. There is no family values. The life in the Western countries have, although we see that it is progressed and all these things, but if we see the real values of life, which our youth are realizing, and it is not that we need to teach everything. It is realized by looking at the societies itself. So we don't have to take any extra efforts to bring youth to these things. It will happen automatically. People are looking at it. Youth is very vigilant and vibrant. They will automatically know that what was ancient is
Right.
good for it. What is Indian values are meant to lead the way. So therefore it will happen. We need not take any special efforts for it.